Of the co-hosts of this event, which is UN ESCAP, UN Human Rights or OETHR, and UNEP, with the kind support from CEDA, I would like to welcome you all to this session on enabling sustainable recovery with greater access to information, access to justice, and public participation in environmental decision-making. Thank you for joining this session. Before we begin the session, I'd like to provide some housekeeping reminders. We kindly ask all participants joining remotely via MS Teams to please keep their cameras and microphones off unless they are invited to take the floor. This is in order to maintain clear and reliable internet connection for all who are joining. We would like to inform all participants that this hybrid meeting is being recorded. It is also being live streamed on YouTube. By participating in this event, you consent to the recording and the subsequent streaming of this footage. We kindly invite you to interact throughout the session via the chat box. Please do join our dialogue and type your comments and your questions throughout the session. We are going to try to address as many questions as we can during the Q&A sections of this session. This hybrid meeting is being recorded. Ladies and gentlemen, today we're going to discuss the procedural rights of access to information, access to justice, and public participation in environmental decision-making. These are at the heart of promoting rule of law and enabling the achievement and of the Sustainable Development Goals. These rights support inclusive and peaceful societies. They facilitate good governance and promote sustainable pandemic recovery. These rights are embedded in environmental law, finding their early reference within Principle 10 of the Rio Declaration on Environment and Development and Public Participation. Strengthened environmental rule of law, and thus strengthened procedural rights, will facilitate institutions to be able to provide access to information, to encourage public participation in environmental decisions, and to facilitate access to justice. Today, we're going to hear from a range of distinguished speakers who will explore the regional and the global trends around these access rights. They will also explore opportunities within Asia-Pacific region. First, we're going to hear from our keynote speaker. I'm delighted to first give the floor to Professor Amara Pongsapit, who is Thailand's representative to the ASEAN Intergovernmental Commission on Human Rights. Professor Amara, the floor is yours.
Thank you, Georgina. Thank you for inviting me to speak today. Let me start by reminding the audience that those of us working in the field of environment remember well that the international conference, which took place in 1972 in Stockholm with the title Human Environment, was the first international conference which brought the two components, human and environment, to the attention of the world. After 1972, many conferences and treaty bodies related to human rights and environment have been adopted. In discussing COVID-19 and enabling sustainable recovery, I'd like to say that COVID-19 is both social and economic crisis. It is a wake-up call for us human beings to recognize the close connection between human beings and other natural beings, i.e. virus, disease, plants, animals, etc. The Human Development Report 2020, titled The Next Frontier, Human Development and the Anthropocene, states that the COVID-19 is the tip of the spear, telling us that we must pay more attention to the relationship between people and nature in the new normal phase. They propose that we are now entering a new geologic epoch, the Anthropocene. That means we are leaving the Holocene geologic epoch. This means that humans are a dominant force shaping the future of the planet. The UNDP report believes that we are facing the uncertain futures to embark on bold new paths. The new normal should be nature-based human development. Our experience in the pandemic and transboundary nature of COVID-19 make us realize that the efforts needed to recover from the pandemic must be transboundaries. To recover from the pandemic together, all countries must commit to work together to achieve the same goal. The Sustainable Development Goals introduced since 2015 is very relevant here. For the discussion today, the categories which are essential for the sustainable recovery from the pandemic are goals 16 and 17, which require procedural commitments and can be classified as procedural rights. Goal 16 is on peace, justice, and strong institution, and goal 17 is on partnership for the goals. I strongly believe that working together, we should be able to achieve goal 6. In the past few decades, since 1972, we have managed to make some progress in changing our mindsets. I'd like to mention here some paradigm shifts in human rights and measurement in development, which took place during the past few decades. Since 1972, we have gone through a few paradigm shifts already. I would like to mention 3. First, the shift in issues, content, and approaches. What happened was that in addition to the civil, political, economic, social, and cultural rights, development has become a human rights issue. The 1986 Declaration on Right to Development has been one of the UN instruments which bring the issue of human-centered development to the global level, stating that the right to development is an inalienable human right. The second shift I would like to mention here is the shift in measurement tools. In 1990, UNDP proposed human-centered development concept and Human Development Index as measurement tool. The Human Development Index, HDI, was proposed to be an alternative to GDP, which is growth-centered. We now have human-centered index. The HDI should be easily usable as the GDP. That was the attempt made by Amartya Sen and Mahbub al-Haq. To be easily usable, they designed composite index. The 3 ingredients chosen are years of schooling, life expectancy at birth, and gross national income per capita. Since 1990, UNDP publishes human development reports annually with human development composite indices in the matrix. Another measurement tool is to measure development goals to be achieved. The Millennium Development Goals, MDGs, proposed 8 goals and 48 indicators to measure development at national level. After 15 years, another important progress is the shift in measurement of development towards sustainable development goals to be achieved in 2030. In addition to the increase in number of goals and indicators, the contrast between MDGs and SDGs is the shift from needs-based to rights-based, shift from focusing on country to focusing on issues. Furthermore, planning process was changed from top-down design to the process involving civil society and all stakeholders. The third shift is shift in roles of non-state actors in development. Previously, the role of state had been very important, but In 2011, UN General Assembly adopted the UN Guiding Principles on Protect, Respect, Remedy Framework for Business and Human Rights. The guiding principles introduced 3 pillars and put clear responsibility to corporate sector in addition to the state. The 3 pillars are Pillar 1, the state duty to protect. Pillar 2, the corporate responsibility to respect human rights. And this means that corporate, the term corporate here, include all partners, both downstreams and downstreams the production line. Pillar 3, access to remedy through judicial, administrative, legislative, or other appropriate means. In terms of business and human rights, the UN Guiding Principles extends responsibility to protect, respect, and remedy to both states and non-state actors. And I think this is very important. My last point is on my personal experiences and concern related to problems in interpretation and implementation of procedural rights. I mentioned earlier that there had been many instruments, but they are not working perfectly. There are some concerns. My first concern is regards to the interpretation of public participation, access to information, and access to justice. The interpretation of public participation by authorities used to be what I call partial participation only, meaning that if certain number of people attended the event, it was sufficient to call the meeting public participation. There are a few available tools to deal with procedures involved in public participation already. It indicates that public participation must take place at all decision-making stages, from the inception of the project to construction, implementation, operation, and at the output-outcome stage. But many organizers prefer the term public hearing to inform public of the event to take place, and furthermore to limit the number of people and the coverage of people to attend the event. Sometimes the term technical hearing is used to exclude those who are considered non-technical. The issue is who should be included and who should be informed. The word stakeholders had come up and has been adopted to include everyone who are involved or being impacted, either directly or indirectly, short-term or long-term, and intentional or unintentional. With regard to access to information, in earlier days, the term access to information is unknown. Some types of information are considered classified and not public. It used to be difficult, if not impossible, to acquire an EIA report. Reports are not made available to people being impacted by new projects to take place in or near the communities. 2 excuses are: 1, the reports are technical and are not necessary for the general public, and 2, business confidentiality, both technical know-how and financial. As for the concept of access to justice, this term has been more recently discussed. The implication here is that in addition to access to information just mentioned, people should have the opportunity to file complaints on negative impact caused by the project. Built-in grievance procedure, mitigation procedures, redress and remedy procedures should be made available in the project implementation document. In addition to agreements and conventions adopted at national and regional levels, such as the Aarhus Convention as an example from Europe, and the Escazu Regional Agreement as an example from Latin America, the UN Guiding Principles on Human Rights introduces a tool called human rights due diligence and another tool, human rights impact assessment, as tools to incorporate public participation, access to information, and access to remedy in the project description and implementation plan. For grievance mechanism, there are both state-based and non-state-based mechanisms, as well as judicial and quasi-judicial mechanisms. My second concern is in regard to the transboundary issues. When I was with the Thai National Human Rights Commission, we received complaints on transboundary investment impacting on local people. There were cases of Thai nationals being impacted by project activities of foreign investors on Thai soil, and cases of Thai nationals investing in foreign soil impacting on local people. The issues involved nationality of investors, nationality of implementing agencies, and people being impacted. The question is, who is responsible for transboundary impact assessment? More recently, issues of construction of dams and infrastructures involving cross-border impacts became very relevant. Construction of dams on international rivers and cross-border air pollution incidents are cases in point. We are now talking about transboundary EIA, as well as application of the UN Guiding Principles on Business and Human Rights. In conclusion, to enable sustainable recovery of the new normal, or what UNDP report called the normality of the Anthropocene epoch, we need to establish recovery strategy which integrate people and environment into a single holistic dimension. This recovery strategy can take into consideration existing instruments and all tools. The recovery strategy needs to be in line with the Sustainable Development Goals. Goals 16 and 17 cover and encourage adoption of practices promoting procedural rights aimed at improving equality, accessibility, and inclusivity through public participation, accessibility to information on environment, and accessibility to justice. For Asia Pacific region, to facilitate the achievement of these goals, 3 options are: 1, propose separate convention or agreement at regional level, focusing on procedural rights similar to the Aarhus Convention for the European region and the Escazu Agreement for the Latin American region. 2, with transnational corporate investment, it is necessary for the UN Guiding Principles on Protect, Respect, and Remedy Framework for Business and Human Rights to be upgraded to be a UN convention. At present, the UN Guiding Principle encourages each country to draw up national action plan to assess human rights activities at the national level. We need regional and global action plan. The last option is to develop transboundary EIA guidelines to incorporate procedures to ensure procedural rights leading to more sustainable, resilient society. With that, I thank you for your attention.
Thank you very much, Professor Amara, for your keynote presentation. And you raised some incredibly important points about the need to ensure that at the heart of recovery are these elements of access to information, access to justice, and public participation. That these elements need to consider who should be included, and indeed the very process of how those individuals and groups are included. We need to think beyond national approaches to transboundary approaches. We need to ensure that there are regional agreements and regional consensus around the need for such measures. Also important are the underlying principles that can be found in the UNGPs on business and human rights. and the lessons we can learn from similar regional agreements in Europe and in Latin America and the Caribbean. Indeed, we're going to now move to our next panel, in which we will have representatives from the various economic commissions in Europe and Latin America and the Caribbean, who will share their perspectives on the lessons learnt and the opportunities from the Aarhus and Escazu agreements, as well as hearing from the Economic Commission in our region to learn about how such lessons may be applied and what we can do in Asia and the Pacific. This panel is going to respond to the question of what are the benefits of regional mechanisms to enable sustainable recovery from COVID-19 with enhanced access to information, access to justice, and public participation. In this panel, I am delighted to have Fiona Marshall, Environmental Affairs Officer from the Aarhus Convention Secretariat, UNECE, David Barrio, Environmental Affairs Officer from the Escazu Agreement Secretariat in UN ECLAC, and Katinka Weinberger, who is the Chief of the Environment and Development Policy Section of UN ESCAP. Thank you very much to all of you for joining us. I am first going to give the floor to Fiona Marshall to give us the perspective from the Aarhus Convention Secretariat. Fiona, thank you very much. The floor is yours.
Good afternoon, everyone, from the snowy mountains of Switzerland. I would like to share some of the benefits that parties to the Aarhus Convention have reported about being a party to the convention. These benefits applied both before the pandemic, and also they will apply during the subsequent recovery phase too. First, a brief introduction to the Aarhus Convention. It was adopted in the Danish city of Aarhus in 1998, which is why it is known as the Aarhus Convention. It entered into force in 2001, which means that this year it celebrates its 20th anniversary of being in force. The objective of the convention is that in order to contribute to the protection of the right of every person of present and future generations to live in an environment adequate to his or her health and well-being, each party shall guarantee the rights of access to information, public participation in decision-making, and access to justice in environmental matters. In addition, the Aarhus Convention requires parties to ensure that persons exercising the rights under the Convention are not persecuted, penalized, or harassed in any way for their involvement. It currently has 47 parties. It is sometimes mistakenly called a European Convention. In fact, its parties to date range from Western Europe to Central Asia. Importantly, it is open globally to accession by any UN member state, and Aarhus parties have strongly welcomed the interest of any UN member state who would like to join. Even in the case of a crisis, such as the COVID-19 pandemic and the subsequent recovery phase, the binding rights set out in the Convention cannot be reduced or curtailed. Rather, if the established practices for ensuring access to information, public participation in decision-making, or access to justice in environmental matters cannot be used, alternative means must be used to fulfill the requirements of the Convention. I would now like to share a sample of experiences reported by governments of how the Aarhus Convention has helped in their country. Tajikistan says that thanks to the Aarhus Convention, its people have learned how the state of the environment and natural and man-made disasters impact on the health of its population. As a result of the convention, important laws have been adopted on environmental information, on citizens' appeals, and on environmental audits. Due to the convention, access to environmental information has improved significantly, a legislative framework has been created that enables people to ask for environmental information about the area where they live and to participate in decision-making on environmental issues. Concerning public participation in decision-making, the Deputy Prime Minister of Romania says, "The Aarhus Convention is one of the key elements in promoting environmental democracy and plays an essential role in bringing civil society, local communities, and individuals closer to decisions that could impact them directly. Their participation improves decisions and facilitates those decisions' implementation." Regarding access to justice, Malta says that as a result of the Aarhus Convention, it has established an Environment and Planning Review Tribunal to provide more effective and accessible access to justice in cases relating to the environment. The tribunal is expeditious and not costly, and individuals may gain standing without having to prove a legal interest. As a consequence, it has created a broader and more transparent forum for challenging decisions relating to the environment, valuing environmental protection as a public common interest. Regarding how the Aarhus Convention has benefited in its country, Georgia has spoken of the results achieved by its Aarhus Center, which was established in 2005 with the assistance of the OSCE. The Aarhus Center works to guarantee the full and proper implementation of the Convention in Georgia. Among many activities, this includes assisting the public to have easy access to environmental information, helping to organize public hearings on important strategic policy documents and projects, providing free legal consultation on environmental matters, and training Georgian judges about the Aarhus Convention. Georgia says that as a result of the Aarhus Center, the public has become more active and competent in environmental matters, and environmental accountability of both public officials and developers has increased. The Deputy Prime Minister of France says that the Aarhus Convention is a global benchmark for environmental democracy. It allows everyone to become a real actor in decisions affecting the environment. For young people, this convention is particularly valuable. It is a guarantee that the world under construction will be done by involving the public in decisions important to the future of the planet. By helping to preserve our environment, the Aarhus Convention also makes a useful contribution to the achievement of the 2030 Sustainable Development Goals. In closing, even during a crisis such as the COVID-19 pandemic and the subsequent recovery phase, the binding rights set out in the Convention cannot be reduced or curtailed. In this way, the Convention contributes to the right of every person, of both present and future generations, to live in an environment adequate to his or her health and well-being, even through the most difficult times. Thank you.
Thank you very much, Fiona, for that intervention. And I'm now delighted to turn to a different region, to David Barrio, who will speak to us about the lessons we can learn from the Escazu agreement. Thank you, David.
Thank you very much, and happy World Water Day to all, and happy anniversary as well to the Aarhus Convention on its 20th anniversary. I'm particularly pleased to join you from ECLAC in Santiago, Chile, and would like to start by thanking the organizers for the invitation and recognizing my fellow panel members, as well as our distinguished audience. The question being posed today is particularly timely and relevant in the region I represent, Latin America and the Caribbean. As in other parts of the world, we have been hard hit by the pandemic. And there is one lesson, if there is one lesson we can draw from this crisis, is that regional multilateralism is more necessary than ever, that regions are pivotal for sustainable recovery. I'm pleased to shed some light and share our experience from the Escazu agreement, which constitutes a prime example of such concerted regional action and is currently experiencing encouraging times, We are actually in the final countdown to its entry into force in exactly 1 month from now, on the 22nd of April, Earth Day, so it has become a beacon of hope and inspiration charting the way ahead. For the sake of those that may be less familiar with it, allow me to provide a few basics. As you can imagine, and as in the case of the Aarhus Convention, the treaty in Escazu has a much longer name. Officially, it is the Regional Agreement on Access to Information, Public Participation, and Access to Justice in Environmental Matters in Latin America and the Caribbean. It takes its short name from the place of its adoption, Escazu in Costa Rica, and it originated in Rio Plus 20, came to fruition almost 6 years later in 2018, when it was adopted and opened for signature. The agreement is a game changer in many ways. It is the last multilateral environmental agreement to have been concluded. It is the region's first environmental treaty. It is the only one resulting from Rio Plus 20, and the first to be serviced by ECLAC. But perhaps most importantly, it is particularly innovative due to its inclusion of specific provisions to protect human rights defenders in environmental matters. Open to the 33 countries of Latin America and the Caribbean, it currently has 25 signatories, 2/3 of the region, and 12 parties. As I was saying, the Escazu Agreement represents one of the most ambitious and forward-looking regional efforts to tackle many of the environmental challenges we are facing, particularly in a COVID-19 context. And it is a product of its time. Latin America and the Caribbean is blessed with tremendous natural capital, but we are also one of the most affected by climate change and biodiversity loss. Although we may not be the poorest, we are the most unequal region in the world. And such inequality is also expressed in environmental terms. The most vulnerable, the most remote populations suffer environmental harm also the most, and face greater obstacles to exercise their human and environmental rights. And in addition, we are one of the most dangerous regions in the world for the defense of the environment. According to recent reports, 2/3 of the murders of environmental activists occurred, sadly, in our region. So this context has not only boosted regional cooperation, but also shaped the contours of the agreement. From its objective to its different pillars and provisions, you will see that its driving forces are the implementation of access rights, as opposed to mere recognition, so it goes a step beyond. Also that equality and non-discrimination are basic cross-cutting themes. Attention to vulnerabilities, to persons and groups in vulnerable situations, and capacity development, capacity building. In turn, openness, transparency, and public participation were a hallmark since the beginning, in the understanding that the process is as important as its results, and that countries needed to lead by example. Now turning to the benefits of the agreement to build forward better in times of COVID. Like Aarhus, Escazu speaks to regional cooperation and partnerships. It is premised on concerted action, both among states and within states. And it is cognizant of the fact that no single country, no single government or actor can successfully tackle environmental challenges alone. Therefore, it empowers societies to act, to react, to transform for a common purpose the environment. And it further recognizes that if the environment is the basis of our existence, our well-being and development, then everyone must be informed about it, must have a say in it, and must be engaged in preserving it. This is all the more important in a COVID-19 context. As the UN Secretary General pointed out in his policy brief on the impacts of the pandemic in Latin America and the Caribbean, the Escazu Agreement is a valuable tool to seek people-centered solutions grounded in nature. And it equips countries better to address the most pressing environmental concerns. This is done by enhancing access to data, knowledge, information, but also by engaging vulnerable groups, putting in place inclusive and community-oriented actions, and upholding fundamental values, as well as fostering responsive public policies and institutions. I would say there are 5 main ways through which the Escazu Agreement facilitates sustainable recovery. First, it levels a playing field. It offers a common narrative, a regional standard that is shared by and applicable to all, also in times of crisis. Second, it puts people and rights at the core of policies and responses, ensuring that no recovery effort goes to the detriment of the populations and their environment. Third, its emphasis is on persons and groups in vulnerable situations, which the pandemic has accentuated, thereby targeting specifically those at greatest risk and reaching those furthest behind. Fourth, the agreement preserves life, life on land, underwater, and also the life of those who defend life, environmental defenders. Unfortunately, COVID-19 has neither halted the climate or biodiversity crisis, nor the attacks on environmental defenders in our region. And finally, by implementing access rights, the agreement favors peace and justice and prevents conflict. Most environmental disputes in the region are associated with a lack of meaningful engagement in the decision-making process, also to a lack of accountability, transparency, and effective access to redress and remedy. In sum, Escazu strengthens environmental due process and environmental rule of law, and the agreement is also based on progressiveness and non-regression, giving sufficient leeway to move forward, but also preventing rollbacks. So to conclude, I would like to refer to some Escazu key takeaways. What has the Escazu experience shown us and also shown the rest of the world? Well, first and foremost, that the region and regional action is a driver of environmental stewardship, also in times of COVID. A treaty that is inclusive, openly negotiated, that puts the needs, priorities, singularities of the countries at the center, and that targets the well-being of societies, places us in a better position to deal with environmental challenges. An agreement such as Escazu offers a roadmap, legal certainty, trust, legitimacy, and lays the foundation for sound economic and social policy. However, processes do not happen overnight and take time. And as they say, it doesn't matter how slowly you go, as long as you don't stop. Over the years, Escazu has demonstrated that a region can come together for the greater good, despite any cleavages and disparities that may exist. Forging compacts and partnerships is possible, and finding unity in diversity and purpose has been effective. Our experience, at least, has shown that very dissimilar countries can join efforts to reach impactful outcomes. For example, countries of continental size, such as mega-diverse Brazil, an Amazon country with 210 million people, can reach an agreement as valuable for them as for one of the smallest countries in the world, such as St. Kitts and Nevis, 52,000 strong, and in the front lines of climate change. OECD countries, such as Mexico and Colombia, can cooperate with some of the poorest, like Haiti. The agreement has found common ground as well between different legal systems and traditions, and become meaningful to different realities. It shows, therefore, that success is the sum of all small efforts. And it has become a convening platform, a way of acting, a way of thinking, a way of recovering, even a household name. But it requires leadership, champions of the cause, going beyond the usual suspects and the converted ones, and generating a critical mass, local and regional ownership. So dear moderator, distinguished panelists, delegates, colleagues, friends, coming back to the initial question, I would make it short. Certainly regional mechanisms have tremendous benefits and full potential must be made of them. So I therefore cannot but encourage similar approaches and invite you to make environmental access rights the cornerstone of recovery efforts. Thank you again for the opportunity, and back to you, Georgina.
Thank you very much, David, for that intervention. We're now going to turn to Katinka from UN ESCAP to explore the opportunities in the Asia-Pacific region. Katinka, you have the floor.
Thank you very much, Georgina. Here in our region, we do not yet have a regional mechanism, but in my short intervention, I will argue that such a mechanism could bring very important benefits to Asia and the Pacific. As previous speakers have already emphasized, access rights are closely linked to the success of the entire 2030 agenda, not only SDG 16. We have very good evidence that environmental rights provisions are linked to better environmental outcomes, and that the recognition and the protection of environmental rights are linked to faster improvements also in environmental quality. But Asia and the Pacific exhibits some major disparities in the Global Environmental Performance Index. Some countries from our region score very high, while others score really low. The strengthening regional dialogue on enhancing access to information, access to justice, and public participation in environmental decision-making can be an opportunity to accelerate action and to increase environmental performance in our region, as it provides an opportunity for countries to learn from each other. Goal 16 on peace, justice, and strong institutions is one of the 3 SDGs with the lowest and the poorest data availability. Here in our region in Asia and the Pacific, only 1/3 of SDG indicators for that goal have sufficient data. And without sufficient data, of course, it's really impossible to get a full picture of progress or regression. But there is evidence. For instance, between 2015 to 2019, at least 472 human rights defenders, journalists, and trade unionists were killed, and 21 forcibly disappeared in 24 ESCAP member states. We know that defenders of environmental rights are particularly at risk, as they are subject to harassment, to arbitrary arrests, to detentions, threats, and killing. In 2019, 53 land and environmental defenders were killed in Asia and the Pacific. There are really fundamental underlying challenges in our region which hinder the environmental protection and sustainable development, and they include gender imbalances, which persist in political participation. They include a declining civil society participation. They include convergences between inequality and climate change, and in some countries of our region also obstructed and narrowed and repressed civil spaces. There is evidence that since the outbreak of COVID-19 and the subsequent lockdowns, restrictions on civic space and fundamental freedoms more broadly have continued to tighten in 2020. Of 25 countries here in Asia that were assessed, 4 were rated as closed, 9 as repressed, and 9 as obstructed. Overall, the COVID-19 crisis has exposed underlying issues of exclusion, racism, and xenophobia in many countries in our region. But looking forward, as we have moved into the UN Decade of Action to accelerate progress in the region and to achieve real transformation, we can and also we should not lose sight of the need for an empowered, inclusive, and equal Asia and the Pacific. As part of a project that we had developed with the government of Sweden, we have identified elements and factors for inclusive engagement of marginalized and vulnerable groups for better environmental outcomes, which go beyond the partial participation that our keynote speaker referred to earlier. These include removing institutional and structural barriers that inhibit and restrict vulnerable and marginalized groups from access to resources. It includes providing space for deliberation and dialogue. And this works well, especially in spaces that are designed to promote equity and enable nested decision-making. Enabling ownership by promoting the ability to define the objectives that affect outcomes and influence the decision-making processes. And finally, the institutionalization of engagement processes as a way of ensuring that the needs of marginalized and vulnerable groups enter formal planning processes. We believe that meaningful engagement could enable a sustainable recovery, very much as pointed out by the previous speakers, if member states in our region are able to provide greater access to information, access to justice, and public participation in environmental decision-making. The COVID-19 pandemic has aggravated existing challenges, and their impacts are represented unevenly among vulnerable and marginalized groups, including women and indigenous communities. As we recover from the devastating consequences of the pandemic, empowerment is one of the key elements to guarantee that we have all stakeholders on board for recovery to truly leave no one behind. And beyond that, the pandemic has also underscored how we must enhance regional cooperation to continue safeguarding ecosystem health, to prevent the spread of further zoonotic diseases and other environmental disasters, which all happen to be transboundary challenges. And in this regard, a regional mechanism in Asia and the Pacific could be an enabler as we make gradual progress in recovery with more access to information, justice, and participation within the overarching goals of the 2030 Agenda. Thank you.
Thank you very much, Katinka. So we have reached the end of our first panel, but I want to provide the opportunity now for a special intervention. I would like to invite Åsa Hedden, Head of the Regional Development Cooperation in Asia and the Pacific, the Embassy of Sweden in Thailand, to please make an intervention in reaction to this first panel. Åsa, you have the floor.
Thank you so much. Good afternoon, ladies and gentlemen. I would like to thank you and ESCAP, UNEP and OHCHR for hosting this side event today. The COVID-19 pandemic is really holding back progress on the Sustainable Development Goals. Despite this, we must keep our promise to the people and the planet. So more solidarity, more coordination and more sustainability are needed now more than ever. From the partnership with ESCAP that Katinka just mentioned, through our annual partner meeting, back to back with the APFSD 2019, an in-depth understanding on the role of empowerment and public participation to accelerate the implementation of environmental related sustainable development goals has increased among our stakeholders. The right to access to information is necessary for empowerment, engagement, and greater accountability. We are very pleased that the discussions around this topic from 2019 has now evolved leading up to this side event today, where the regional dialogue on access right has been discussed with key stakeholders in the Asia and the Pacific region. The lessons learned from the Aarhus Convention and Escazu agreement from the previous session are very valuable for our learning, and we hope it can be an inspiration for the regional dialogue also here in Asia Pacific. Since 2005, Sweden has been a party to the Aarhus Convention. With regard to the openness to the public, Sweden has a very long tradition of well-functioning regulatory framework with the same purpose as the convention and positive experiences in its application. The public's right to access information from public authorities contributes to good cooperation between decision makers, public and to an increased exchange of knowledge. There is also a long tradition of public participation in decision-making processes in the environmental area. For more than 40 years, there has been an environmental permit process for industrial activities and other environmental hazardous activities, such as sewage treatment works and waste treatment plants. Permit processes involve consultations with the public before a permit application is submitted to the authority, and this was a practice even before the convention was ratified. An example of national criteria that would not be in compliance with the convention was the former Swedish criteria for NGOs. According to a former Swedish law, to be able to appeal environmental permits, environmental associations were required to have at least 2,000 members. And this was found by the Court of Justice to the EU to be in violations of the EU legislations intended to implement the Aarhus Convention. And subsequently, the Swedish law on access to justice for NGOs was changed as a result of the court decision. Sweden would also could improve in some aspect to the implementation of the convention. For example, the awareness of the purpose and implementation of the convention would need to be strengthened among a wider range of actors in Sweden. In addition, environmental information is currently disseminated on a large number of authorities and websites, which means that it could be difficult for the public to have a comprehensive overview of all the environmental information. I believe more comments will come from CSO on the draft report, on the Swedish draft report, and the progress made since 2017, prior to the meetings of the partners in October this year. So we are also in a learning process. Again, I would like to welcome this initiative to have a regional dialogue on this issue. For the Swedish regional strategy for development cooperation in Asia Pacific, we're focusing very much on the integration of human rights, gender equality, environment, and climate. And the topic today is at this event is clearly very much linked to our strategy. It would be interesting to know how international development cooperation can contribute to the learning process in this region on the access to justice and public participation in environmental decision making. Thank you so much for the attention, and I would look forward to the panel discussion.
Thank you very much, Åsa, for that intervention. So I'm going to give Fiona and David the opportunity to respond to the question that is posed by Osa. But if I can ask you to provide a very short response, and then we will receive additional questions at the end of today's session that there may be opportunities to respond to at that point. So in order for us to move on to the second panel, I'll ask David and Fiona to give a quick response to exactly the question from Osa, which is how can international development contribute to the learning process, particularly on a regional approach to access rights? So let me first turn to Fiona.
Thank you very much, Osa, for that very good question. Actually, I would like to go back to the example that I provided regarding Georgia, when I spoke about the Aarhus Center that had been set up in 2005. So that Aarhus Center is one of, I think, about 14 or 16 Aarhus Centers that have now been established in different parties to the Aarhus Convention with the support of the OSCE. And so the OSCE is supporting both civil society and governments to establish in these countries centres which can act as a central point for promoting the implementation of the Aarhus Convention in that country. So each centre is set up in its own way by the government or civil society or a combination of both, and it responds to the specific needs of that particular country. So this is one example. I could give others, but I think I should give David a chance for time reasons.
Thank you, Fiona. David, over to you.
Yes, thank you, Georgina and Fiona. Definitely international development cooperation has been also fundamental in Latin America and the Caribbean. And I can also bring a few examples of donors, of partners that have strengthened at the national level and even the sub-regional level environmental access rights. For example, in the OECS, which is the Organization of Eastern Caribbean States, which groups 6 of the smallest islands in the region, we are developing jointly with other partners sub-regional environmental information system, precisely because of the capacity needs and the resources are better maximized through sub-regional approaches. So that's an example there. Another area would be through the German, EU, and French cooperation. We're working on natural resources management in compliance with Escazu agreement requirements. So we're working with Andean countries, those that are along the Andes, to mainstream human rights impact assessments and due diligence in company activities. So those are 2 very basic examples. But if I may add also an additional element in addition to international development cooperation is the multilateral development banks. The IADB, the Inter-American Development Bank, recently included Escazu within their environmental safeguards, and that has also given a push. It's giving really the emphasis on access rights in all the projects and activities funded by the bank. So it encouraged those avenues to be explored as well in other regions. Thank you.
Thank you. Very important points raised. So at this point, I would like to thank all of the speakers in our first panel. Please, if you have time, please do stay because there may be questions that will be posed to you at the end of the session. At this point, I would be delighted to hand the floor to my co-moderator, Ramchat Wachiraratnakonkul. How did I do? Who will now moderate the second part of this session. Thank you so much, Ramchat.
Thank you, Georgie. Welcome everyone to the second panel of today. My name is Ramchat from the UN Human Rights Office, Regional Office for Southeast Asia. And in this second panel, we have 3 distinguished speakers who will share their insights and will respond to the question of how can inclusive and participatory decisions making accelerate as sustainable post-pandemic recoveries and promote the achievement of the globally agreed environmental goals. Before we get started, I would like to remind you, if you would like to ask the speakers the question, please feel free to type your question or comments in the chat box, and we will address these questions at the end. I would like to start with our first speakers today. We have Professor Vitit Mandrapon with us here in the ESCAP building. And Professor Vitit, he is the Professor Emeritus at the Chulalongkorn University. He is also the former UN Special Rapporteur, UN Independent Expert, and the member of the UN Commissions of Inquiry on Human Rights. Professor Vitit, the floor is yours.
Thank you very much, and I'd like to thank our UN friends for the invitation to be here. In the 5 minutes that we have, I would like to make 5 points as preliminary points, the past to the present, and then 5 points, the present to the future. The first point, learning from the past, is that there are various principles that have not been mentioned yet, which preceded the Sustainable Development Goals. One very important principle of international law, international human rights law, is the precautionary principle, whereby even if you don't have all the data, preventive measures must be taken to prevent possible potential damage, both internally and in the transboundary fashion. Secondly, a second principle that hasn't quite been mentioned is that where the environment relates to and interrelates with human beings in terms of relocation, there is a key principle of the need to consult, enable participation, and respect the free, prior, and informed consent of communities, particularly traditional communities, indigenous peoples, before any decision-making is taken. And that means good dialogue and good compensation, good remedy, particularly where relocation ultimately might have to take place. So that's the first consideration internationally. The second consideration, I want to learn a little bit from Thailand, and it's this. We've learned over the past 30 years that advocacy in this regard is not only of individuals, but must be advocacy and respect for the community. In other words, the emergence of community rights as advocated through our constitution. And there have been key court cases vindicating the rights of communities in this regard. Secondly, what we've learned to do and not to do in terms of data and assessments, famously and infamously, human rights impact assessment perhaps, but evidently environmental impact assessment and more lately health impact assessment. What we've learned not to do is, of course, to lack the data, or particularly obsolete data appearing when we need up-to-date data, quality data, as well as greater participation of stakeholders. And we've learned, particularly from vetting from the UN, that there is a question as to who validates the data, who validates the environmental impact assessment and health impact assessment. There has been a question in regard to the credibility of the third parties who come in to validate data and assessments with a view ultimately to undertaking certain environmental projects. The third preliminary consideration is that we have now arrived at the juncture of the SDGs, happily, from 2015, and there is a certain value added that we can market well. Number one, as a component, it offers us, unlike human rights, it offers us a policy framework of time. We want to achieve in 15 years the various goals, 17 goals, 2015 to 30. Secondly, there's been global buy-in, particularly by Asian states, and that's good, but buy-in does not mean necessarily good implementation, though. Thirdly, SDGs help to generate data, but we do have difficulties in regard to what is known as tier 2 data, where we have a sort of methodology to collect, but we don't collect so well. Tier 1 is what's been collected already, such as the number of unsentenced prisoners in prison, for example. Fourthly, as a subcomponent, we welcome the integration of the 17 goals from a human rights perspective. In other words, there's more of a horizontal perspective interlinked with states. And fifth, the key goal today is 16, SDG 16, but it must not be approached from a silo approach. Fourthly, we come to the SDGs themselves. And recently, I would just note that ESCAP issued just last week an appraisal of what's been happening in the Asia-Pacific region. And I would voice 2 or 3 interesting findings, both at the regional level as well as the sub-regional level, particularly affecting ASEAN in the latter. The most recent SDG report from ESCAP notes the following regression. I will not talk about progression so much because there hasn't been much, but regression is of concern. The AP region has been suffering particularly from regression on SDG 13, which is about climate change, and SDG 14, which is about marine pollution, life below water. So be very careful there, because those indicators, those goals are very much linked with the environment beyond 16 and yet shape 16 that we're talking about. From the perspective of Southeast Asia, with a good resonance for ASEAN, we have been regressing at least on 3 issues. Number 1, SDG 13 on climate change, regressing. Number 2, SDG 14 on life below water, and famously SDG 16 in regard to peace and inclusion, precisely because 16 is about human rights, the environment, peace, and impliedly democracy. So where are we on democrats in this region at this point in time, I ask indeed. Likewise, we are also happy if we can do better on SDG 17, which is to do with partnership. Finally, as a preliminary consideration, I would just note that SDG 16, which is the focus of today, has 3 basic components as linked with our topic. Number 1, access to justice, which is under goal 16.3, target 3, which is very much to do with, for example, collecting data on unsentenced prisoners. SDG 16.7, which is my topic on participation. That's the target, participation. And what are we looking for? We're looking for data, action on proportion of participation, including women, in local and national institutions as one indicator. And as another indicator, we're also looking for data on proportion of the population who believe decision-making is inclusive and responsive. And, interesting, this is a gray area because it's a tier 2 consideration where we don't have enough data also on gender and democracy, I'm afraid. Finally, on SDG 16, pertaining to the other angle, which is access to justice, the sort of data we're looking for through SDG point 10 include access to information and protection of freedoms. We've heard already, we have some data on killings, sadly, torture, sadly, and so on. But we're also looking for data on constitution and other guarantees of public access to data. And happily, we do have some data on this, such as about 31 UN ESCAP countries now have some guarantees for access to policy data. That is welcome. So those are the 5 preliminary ones. And let me finish with 5 past, present, and our present to future very quickly. Number 1, COVID. COVID is a challenge now and beyond. Why? Because 1, we see the ascendancy of the executive branch. Every country has witnessed the executive branch gaining more power with concomitant considerations, including dangers. Number 2, medical interventions are welcome and they comply with human rights to some extent, but medical interventions have also been used to clamp down, lock down on freedoms such as freedom of expression and association assembly, famously, infamously by the use of the emergency decree in various countries. And thirdly, as a challenge from COVID, the weakening of checks and balances. Executive branch has prevailed mainly. Courts don't like to question at this point in time, and even Parliament is a bit dormant here and there. So please be careful in COVID times, even though we welcome good policy and practice on medical interventions. Secondly, let's get to data. We welcome now and for the future more transparent data, and that's got to be linked with public hearings, maybe EIA, maybe HIA, but a broader perspective of stakeholdership. Secondly, we want quality data which are also disaggregated to reflect various concerns, various vulnerabilities. Thirdly, we are also welcoming guarantees in terms of access to data. And we notice, for example, new laws or relatively new laws in Indonesia, which guarantee access to public data. Fourthly, even though countries have been guaranteeing some access to data, they also have famous exceptions, usually national security and confidentiality, and those exceptions must be treated from the angle of reasonableness. We have tests in terms of legality, necessity, and proportionality coming into play in terms of restrictions on the basis of public policy or national security. And finally, the data issue invites us not only to look for environmental data, we are looking for data on transgressions. How many people are killed? How many people are forcibly disappeared? How many torture situations? We have some data, but not complete data. And ESCAP has also referred to various hundred cases to date, but they're not complete data on these violations, sadly. Thirdly, on public participation, which is my topic now, I would say very much that this is linked with political rights and freedoms. Civil, political, economic, social, cultural rights, and environmental issues come together, and we have to take stock of political freedoms, particularly freedom of association and expression, which are being clamped down in many countries today. Secondly, the broadening of the need for public hearings and beyond, in terms of a broader stakeholdership through AIA, HIA, and beyond. Thirdly, environmental impact assessment tends to be to do with medium and large scale projects. We also need to take stock of small scale industries, small scale activities that have impact on the environment, even though there might not be a stipulation in terms of the need for environmental impact assessment. Another issue is to bear in mind the principle of free, prior, and informed consent if we're dealing with dislocation, relocation of traditional communities. And very importantly, next, the issue of human rights defenders being attacked when they're trying to participate and advocate. We have the well-known SLAP cases, strategic litigation against public participation, happening in many countries where reprisals and attacks are carried out vis-a-vis human rights defenders and including environmental human rights defenders. Another element that we welcome to address that, of course, is to learn from Aarhus as well as Escazu. But please don't forget also that we are faced with different political conditions. We are dealing in Asia oftentimes with non-democratic systems, and we should not forget that. It is not quite Europe, you know. Finally on that, for human rights defenders, we have some encouraging signs too. Let's not be negative. The Philippines and Mongolia have examples in terms of setting apace possible laws to protect human rights defenders, and this now found in recent UN literature. Fourthly, and almost to the end, what about access to justice? Quickly, of course, judiciary, yes, but access to judiciary today is also faced with compliant, dormant judiciary in the era of COVID and beyond, particularly in non-democracies. Secondly, we don't refer to just formal systems. We also refer to non-formal mechanisms such as mediation as possibilities. Thirdly, what about half formal, half informal, particularly national human rights institutions? Fourthly, we have AICHA here, the ASEAN Intergovernmental Human Rights Commission. We hope that there'll be an entry point in terms of living testament from AICHA on this one. Fifth, in fact, we're not going to bank on one. We're going to bank on several. We don't believe in monopoly of power. We want checks and balances against monopoly of power. Also in regard to access to remedies, please. So look to a variety. Plus the need for remedies, the need for protection of human rights defenders and beyond, and the need to deal with emergency measures that constrain rights and freedoms. The need to advocate the test of reasonableness through the principle of legality, necessity, and proportionality. In many situations, constraints are not imposed reasonably, sadly. And finally, yes, we're dealing with governments, but we're also dealing with non-government actors, including the business sector. And as has been voiced, we have UN guiding principles on this, including the need for human rights due diligence, to respect the framework for human rights, as well as to ensure accountability ultimately, perhaps through a more detailed human rights impact assessment, with due regard to access to a variety of remedies. Last but not least, where are we next? Well, number one, for the future, let's implement well what we have. We can always advocate new mechanisms, but please implement well what we have, or at least ratify the international treaties that we have. as well as whatever regional entry points we have. You can have new instruments, but let's implement well what we have. Secondly, let's look to a regional value added, which can offer a variety of possibilities. Maybe this ASEAN region can look to various soft law options, such as guidelines, or just to implement the guidelines on business human rights as a soft law option, perhaps. We can have harder law options, such as conventions and treaties at the regional level, such as Aarhus or Escazu. And or we can just highlight good practices and ensure good peer influence to have a ripple effect. And there are two which I would cite here, interestingly. During COVID, Bangladesh has introduced online bail access. Bail applications have led through online access to 10,000 detainees being released at this point in time. I think Thailand has something to learn from there, please. Another example is accessible and mobile services. I think here we advocate very much from the disabilities angle that we should ensure access to Braille and beyond, including on environmental issues, and of course, protect human rights defenders who are working on all these perspectives. Last but not least, please don't forget the relationship between human rights, peace, sustainable development, and democracy, which isn't quite mentioned in SDG 16, but it is incumbent on us to mention it very strongly, please, together with gender sensibility and beyond in terms of others needing attention. So I round off with three maxims for the future, please. We used to say no man is an island. I'm not going to say that anymore because I don't want to forget women and others. So let's say now no human is an island. Secondly, beware of the sinking island. The world is sadly leaking. Third, we're not daunted. We want to offer hope, optimism, and constructive action. So let's ensure through good cooperation at different levels, ensure that the island stays afloat, famously, perhaps with buoyancy and resiliency. Thank you.
Thank you so much, Professor Wikit, for touching up on various issues on data collection and provide us the holistic view of past, present, and future scenario of the COVID-19 recoveries. Now, I would like to hear from our second speaker, Ms. Joanne Carling. Ms. Joanne is the co-convener of the Indigenous People Major Group for Sustainable Development. Joanne, the floor is yours. Thank you.
Thank you, and thank you for having me in this very important conversation. In inclusive and participatory decision making can accelerate sustainable post-pandemic recovery and promote the achievement of globally agreed environmental goals based on the following key elements from my perspective. First, ensuring that vulnerable and marginalized sectors as having a voice and a space to raise their concerns and to be heard without fear. I want to emphasize that point, that we should be able to speak out without fear. This means that it requires the respect for the fundamental rights and freedoms of civil society as an enabling environment for us to be able to participate in decision making. This enabling environment is actually a major challenge in Asia, with increasing number of governments imposing restrictions to freedom of expression, organization, and assembly in the guise of COVID protection, against COVID. I will not repeat this as a lot of the earlier speakers have mentioned this, but just to emphasize that the respect for the fundamental rights and freedoms of citizens is an urgent need if we want effective participation. Second point is the inclusion and participation also require the need to respect the rights of marginalized sectors. In particular, I'm coming from Indigenous peoples, is the need to respect our rights as protected or affirmed by international human rights instruments, particularly our rights to our lands, territories, and resources, to self-determination, and to our cultural integrity. Any action for the pandemic recovery that affect any of these rights require our free, prior, and informed consent, which was mentioned or stressed by our earlier speaker. So thank you for that. And in this context, we are actually alarmed that many of the economic recovery targets of governments in Asia are again targeting our resources for mining, including coal, such as in India, or unsustainable use of our lands for agribusiness expansion, like deforestation and expansion of energy projects that can cause evictions, but also these projects have potential adverse impacts to the environment and destroying our ecosystems. So the importance of recognizing rights as a basis for participation will then allow marginalized sectors to be to deliver solutions, because then they will be able to address also their specific needs. The third point is the recognition and protection and enhancement of the roles and contributions of Indigenous peoples as rights holders and also as stewards of nature. We know that Indigenous peoples' evidence have shown that Indigenous territories are better conserved and have richer biodiversity than those in the hands of government or even big and conservation organizations. However, we are being criminalized by practicing our sustainable livelihood systems. We've seen Indigenous peoples being arrested for taking honey in the forest, for taking wood for cooking or for construction of their houses, or taking non-timber forest products to make handicrafts. Many of Indigenous peoples, as we speak, are languishing in jail simply because of practicing our sustainable livelihoods. And we are even accused as destroyers of nature. This is the big irony, that while we are contributing the most for environmental protection and sustainability, we are criminalized and treated as enemies. And also, in spite of our role for the protection of the environment, we are not even part of any decisions on environmental laws. So how can we also make sure that we are not set aside in the name of environmental protection, that we are not again kicked out by so-called conservation or designation of national parks? And fourth is the inclusion and participation require the political will of states to put into action the recommendations of marginalized sectors in addressing systemic barriers to our invisibility in decision-making. And also, this should include political reforms to repeal discriminatory laws, particularly to Indigenous peoples and women, provide access to information, set up mechanisms for accountability and access to justice, protection of human rights, and mechanisms for democratic participation, and also to formulate with the participation of rights holders in addressing or putting together specific measures and programs to address our specific needs as marginalized groups based on non-discrimination and the principle of equity. Finally, to conclude, I want to say that inclusion and participation in decision-making should not be another exercise of ticking the box on who participated in consultations, but should be anchored in the empowerment of marginalized sectors to be central actors in our global goal for environmental sustainability. And I want to mention that when we say marginalized sector, we exist. We are the indigenous peoples, we are the women, we are the persons with disabilities, we are the small farmers, and we have rights, and we have contributions, and we have solutions. And finally, to say we are protecting the environment, and we need to be recognized for that. Thank you.
Thank you, Joanne, for this powerful statement. And Joanne touched a very important issue about the enabling environment for marginalized groups to participate in the decision-making without fear. And we have heard a lot about the access to remedy and access to justice. So I would like to turn to our final panelist, Judge Brian Preston. Judge Preston is the Chief Judge of the Land and Environment Court of New South Wales, Australia. And Judge Preston, the floor is yours. Thank you.
Thank you. Thank you. I was just going to put a screen share. Well, I was going to do that, but we just had a problem. Yeah. Sorry. All right, so we've just got a little problem there. I'll just, I'll speak. All right. What I'm going to talk about is improving access rights after the COVID pandemic. Now, we've already talked about what are the three access rights. So essentially, it's access to information, public participation, and effective access to judicial and administrative remedies. I'll start with just saying in a brief outline what has been the impact of the COVID pandemic on these access rights. And we can really see it's affected each of them. As far as access to information, there's been a physical restriction. In relation to public participation, it's been curtailed in various ways. And as far as access to justice, that also has been impacted. So let's just start with access to information. To understand why there has been this problem, it's important to understand, as earlier speakers said, that there were already structural and institutional barriers. And one of the restrictions or barriers that was there was that information was typically only available in hard copy. And so to access the hard copy information, you had to go typically to a government office and inspect it. You couldn't take photocopies, you just had to read it there. And so there was, it was difficult to get that access to information. Now, COVID, all the restrictions has meant that the information supplier closed. And so there wasn't able to be any physical inspection of the documents. If you ask for copies, they may not have provided at all, or if they did, it would be at a high cost. And even then, there may be delay because many of the offices closed and people worked from home, and so there was no one to do the copying. And the important point was that there was no alternative access to information. For example, by digitalized information, which was accessible on the internet. So COVID has had a exacerbating influence on restriction to information. There's also been a restriction on public participation. So again, public participation has been limited often to notice and comment. And this mode of participation has been severely restricted because it depends upon access to hard copy information. If you can't get the hard copy information, then you can't make the comment. And even then, you would only be able to comment in writing. So comment in person or orally has been restricted. So there hasn't been a holding of public hearings or meetings. But also there has been more insidious impacts of COVID on public participation. So the drive for economic recovery, because obviously COVID has affected the economy, has meant that governments have seen that we don't have time, we can't afford public participation. So there's been a fast tracking of development projects without any public participation. But worse, as a number of speakers have said, is that when there's been civil society protest about a variety of things done by government, there's been a crackdown on those civil society protests. And it's often done as a cover for denying public participation, or worse, in targeting environmental defenders. The next is access to justice, and that has also been impeded. And it's been impeded, we can see, in three ways. Firstly, in person, court attendances have been vacated and deferred. Many courts with COVID simply put up the shingle and saying that they're closed until further notice. The courts reduced their capacity to resolve disputes. So therefore, there was an increase in delay and many matters that needed urgent action weren't able to be dealt with. Then, because of physical restrictions, access by parties, practitioners and the public to court premises was restricted or even prevented. This has affected open justice, because open justice has been impaired because people cannot see what is going on in the courts. And all of this has led to delay and increased cost for litigation. So that's the gloom story, the COVID cloud. But I want to say that there has been a silver lining in this COVID cloud. And I'll give some example of my court, the Land and Environment Court, because it is an example of what courts can do. And that's what I'm going to talk about that we need to do in the future. The first thing that was done was to change the modes of dispute resolution. So from the traditional modes of in-court attendance by people attending court, it's been changed to utilizing remote technologies. It can be as simple as telephones. It can be using AVL links. It can be using Microsoft Teams, as we're doing now. We have also increased the use of online court for case management, but also for dealing with interlocutory applications. There's also been changes in the modes of giving evidence. So been increased use of technology and pre-recorded evidence. And I want to just run through some of these because, again, courts get stuck in a rut about how evidence can be delivered. So there's been increased use of satellite imagery and mapping. There's been uses of aerial photography. There's been use of drones to take camera footage. There's been use of video and still camera footage. There's been use of pre-recorded videos and evidence statements, which can be played later. There's been screen sharing during evidence presentation of images and documents because it's been allowed, permitted through the Microsoft Teams or Zoom platforms. And there's even been use of PowerPoint presentations in the ways of giving evidence. So it's changed the ways in which we can receive evidence. There's been improvements in open justice. Now, open justice is fundamental to the rule of law and public trust and confidence in the court system. And remote technology can increase the openness of courts by, for example, using AVL and Microsoft Teams hearings. You can open to public generally. There's no limitation on the number of persons that can attend a courtroom. And so you can have up to, 1,400 people participating and watching court proceedings. There's actually improved accessibility because remote technology overcomes geographical inaccessibility. And that's particularly important throughout the Asia-Pacific region, where geographical inaccessibility has been a real barrier. It improves access for vulnerable people, particularly people who are confined or restricted by the COVID-19 pandemic. It assists people with disabilities, especially with physical disabilities, in accessing and participating in hearings and mediations. It also has improved access to information. So the information that is available on court websites has changed and improved so that it gives information about the changed modes of dispute resolution and how to access these modes of dispute resolution. It changes the modes of asking for help. So you don't have to physically visit a court for ask for help. You can do it by telephone, by email, and online, or even set up a Microsoft Teams meeting. It's improved the accessibility of information for people with disability. So particularly for people using accessive technology. For example, all information on the Land Environment Court website now is able to be read through read aloud functions. It improves access to information and documents by making them available on smartphones and tablets. So therefore people can see it on the move. Now, great variety of people have access to a smartphone. So they now can get access to all information through that mechanism. And so we're making all of the information on the Land Environment Court website is now accessible by smartphones and tablets. And it also we've adapted and evolved with upgraded technology. So as technology has improved, we automatically respond and adapt to improve the information provided. It's improved affordability. The use of remote technology can reduce the cost of litigation. No longer do people have to travel to courts, which can be quite significant, and stay overnight in the location of the court and pay for that cost. But there's also a saving in the opportunity costs. People can use that time for other things. So remote technology hearings have saved costs of in-person court attendances. It's also reduced delay, which is saving costs. Because one of the restrictions on the number of court hearings that could be conducted is the physical number of courtrooms. By freeing hearings from the constriction of the number of courtrooms, we can now increase the number of court hearings, which reduces delay. And finally, I want to talk about the idea of integration with other actors in governance systems. And an example is that, well, courts are only one actor in general governance systems, and we can think of that in the planning and environmental systems. So there's a need to break down the silo mentality that many legal and court systems have. So an example in New South Wales is that the planning department has created a digitized system, a planning portal, which has all laws, applications and approvals under the planning system. And the Land Environment Court is working with the government planning department to integrate both the judicial and the planning governance systems so that there's a seamless transition between the two systems. Now, what are the benefits of this integration of the governance systems? Well, firstly, there is an improved access to information, public participation and access to justice in both the judicial and planning systems. It improves transparency and accountability. It improves efficiency and effectiveness. It reduces transaction costs. It improves user satisfaction, and it improves public trust and confidence. So that's some of the what the future is, but the last few points are on the future. Firstly, I see pluralism in dispute resolution. already we were matching the forum, that is the type of dispute resolution process, to the FUS, which is the individual dispute. But we're now matching the form, that is the mode of conducting a dispute resolution process, to the forum and the FUS. And there's a mix and match. We're mixing both the forum, or fora, and the forms for each FUS. The second point in the future is there'll be creativity in delivering access to justice. We can adopt a can-do attitude. And the final point is this: we need systems thinking. We've got to view the resolution of each dispute in the context not only of the dispute resolution by courts, but also in terms of broader governance by the whole of government. So those are my suggestions. Thank you.
Thank you, Judge President, for your valuable example of how can the technologies can be used for accessing to the access rights. I would like to thank you all the panelists for the very great presentation. And now I would like to transition now to our final segment of our event today. I am apologies for because we running a bit late of time, and I hope you can stay with us and hear the last presentation from Matthew Bad, the director of the Asian Research Institute for Environmental Law, and he will share with us the key preliminary findings of the background paper on access rights and the Asia Pacific region. Matthew, you have 5 minutes.
Thank you very much, Konramongchat. And thank you all very much for a very interesting and exciting panel. And I would like to acknowledge first the extraordinary work that Fiona Marshall and David Barrio and Katinka Weinberger have done in terms of looking at the regional approach on access rights. So in terms of just very brief closing on the preliminary findings of this draft report, which should be finalised shortly. And the report was commissioned to review good practice in the UN ESCAP region. You will have to accept that a region with 53 members and 4 billion people does provide some fairly interesting views on access rights and the development of an enabling environment for the practice of those rights. Despite the recent scorecard that showed significant deterioration in the overall level of achievement, especially with respect to SDG targets, there are some areas showing significant improvement, for example, in North and Central Asia. SDG 16 targets that are aligned with procedural rights are critical for effective government and the environmental rule of law. Achieving those SDG targets will also protect environmental and human rights defenders and promote better social environment for the exercise of those access rights. The draft report looked at the development of access rights in the UN ECE and the UN ECLAC region and within the EU itself to look at existing and current development in those access rights. And the report then examined good practices with the Asia Pacific region. It also identified some specific national approaches to each of those rights. And it's certainly fair to say that within that examination, there were very good moments of bright light. There was also some general darkness that was also referred to earlier. So a preliminary finding is that differing regions and country groupings do have differing ways of approaching access rights, and these need to be respected and understood. But I think it's also clear what Fiona Marshall said and what David Barrio said. Within the ECE and also ECLAC, we have a variety of states, aspirations, cultures, norms, and so it is possible to find common ground. And indeed, both the Aarhus Convention and the Escazu agreement certainly show that there are significant advantages to the dialogue process that can recognise those sub-regional differences in approach. For example, it's noted that ASEAN does have a recognition of the right to a safe and clean environment through the ASEAN Declaration on Human Rights. Other areas seem more focused on national constitutional recognition of the right to a healthy environment. In the Pacific, the Convention for the Protection of the Natural Resources and Environment of the South Pacific region has a particular focus on environmental protection and pollution. However, that convention may also provide a useful mechanism to promote access rights through a protocol to that convention. The recognition and protection of Indigenous people and the need to ensure the recognition of the vital role of Indigenous people in environmental protection and resource management is also a very important part of that convention in the South Pacific. It is well accepted that the areas of high biodiversity and ecological integrity still remaining are likely to be on lands that are owned and protected by Indigenous people. And Joan Carling made an important plea for that recognition of those legal rights. And indeed, Ajahn Vichit also identified the role of free, prior, informed consent in ensuring and protecting those access rights. The need to genuinely incorporate and integrate the participation of women and the needs of children in environmental decision-making is also vital to ensure a successful and sustainable post-COVID recovery. So in terms of the role of strong institutions in remedies and justice, it was seen within our examination that providing a sound legal framework is also effective in creating practical institutions that can enforce access rights at a national level. These are very important to ensure that access to justice can be fulfilled. Many judiciaries have developed special procedures for environmental matter that facilitate the commencement and hearing of cases to protect the environment and to protect access rights. And we've heard from Justice Preston in the case of the New South Wales Land and Environment Court, how that can be continued through responding to COVID to ensure that access rights are expanded. Additionally, access to remedies to enforce procedural rights can also be relevant at local levels and through informal, non-judicial mechanisms. And considerable discussion has been raised in many jurisdictions about the role of operational grievance mechanisms and other mechanisms that do not require judicial approaches. In terms of access for information, this is an area of greatest challenge, especially with respect to implementation. The use of modern technology should provide easier access to relevant information. However, this is not always the case. Even when information is mandated for disclosure, there is a need for this to be timely and relevant. Also, there must be a clear mechanism for enforcement of the right to achieve that access to information. Within ESCAP, the Asian Development Bank has adopted a new access to information policy in 2018, a policy that has been recognised as being best practice out of 45 development organisations. In terms of public participation on the surface, public participation is the most widely applied procedural right, although often mostly in the context of environmental impact assessment and strategic impact assessments. Public participation in transboundary EIA and in other forms of environmental decision-making is less well understood. The ASEAN Intergovernmental Commission on Human Rights, AICHA, has been examining the role of procedural rights in environmental impact assessment over the past 5 years. A number of reports and recommendations have identified ways to increase the effectiveness of EIA in implementing and protecting those access rights. But the broader engagement of the public in environmental decision-making is still a significant challenge in the Asia-Pacific region. In terms of the case for regional action, it's clear that global developments in environmental law governing procedural rights provide a solid foundation for establishing a regional framework for the protection of those procedural environmental rights in the Asia-Pacific. The case for a regional arrangement also stems from the notion that a regional approach is the most appropriate means to ensure the implementation of Principle 10 of the Rio Declaration on Environment and Development, owing to the shared issues and challenges in setting standards and strengthening institutional frameworks. Although it must be also remembered, as Fiona Marshall has said, that the Aarhus Convention is the only international convention on access rights. And in terms of a plan of action and going forward, one of the lessons learned from ECLAC in the formal negotiations for the Escazu agreement, a plan of action was developed. And this established 2 working groups. The first worked on capacity building and cooperation, including government and civil society, while the other working group focused on access rights and the development of the draft instrument. A similar approach could be taken in ESCAP. The preliminary findings of this report highlight that there are a considerable number of examples of good practice for procedural rights in the Asia-Pacific region. In both legislation and policy, the experience of ESCAP members can be highlighted to advance the discussion of access rights within the Asia-Pacific region. There is a clear opportunity to use this report and the discussions following this report to support governments through strengthening environmental governance that can support a sustainable recovery post the COVID-19 pandemic. Thank you very much.
Thank you, Matthew. We are all looking forward to read the final report very soon. And As we have heard today, access rights is the key to the post-pandemic sustainable development, and we hope that this dialogue could see around this issue could see the foundation of this wider framework in the Asia Pacific. Apologies for not having time for address the questions, but please note that the recording of the session and the related materials will be available on the event's website next week. And thank you all for your participation, and we looking forward to meeting you again. And thank you all the presenters and the panelists for your valuable insight today. We hope to see you soon. Thank you.